Hello, and welcome to part 2 of our conversation of the Virginia Pretrial Justice System, Fair and Equitable, or Time for a Change, hosted by the Virginia Community Criminal Justice Association. I'm Nick Sainer, President of the National Association of Pretrial Service Agencies Board of Directors and CEO of Justice Point, a nonprofit pretrial diversion and problem-solving court service provider. I will be acting as the moderator of this session, and I'm honored to be sharing this time with an amazing group of panelists. However, before we get to our panelists, I want to do a little bit of housekeeping. First, I want to thank the Miller Center at the University of Virginia providing technical support for both part 1 and part 2 of this forum. Without their help and assistance, this forum would not have been possible. Secondly, we hope to make this session as interactive as possible. And with that in mind, at any time during the session, please use the QA function on Zoom to pose questions to our panelists. We will not be using the raise hand or chat feature. As questions come in, I will do my best to monitor the section and fit those questions in when appropriate. And finally, let's get to our session. Today's panelists will take part in an interactive discussion about criminal justice reform from the national, state, and local levels. The session will start with a keynote, followed by each of the other panelists having 15 minutes to discuss their perspectives on criminal justice reform. We will reserve time after for a more interactive discussion, which will hopefully include audience questions. And finally, we will wrap up the session with brief closing remarks by each panelist. And without further ado, let me introduce our esteemed panelists. First, Marc Levin is an attorney and accomplished author on legal and public policy issues and began the Texas Public Policy Foundation's Criminal Justice Program in 2005. He currently serves as Chief of Policy and Innovation for its Right on Crime initiative, which has become the national clearinghouse for conservative criminal justice reforms. Marc will share his experience on pretrial reform from around the United States and its implications to Virginia. Monica Reid serves as the Director of Advocacy at the National Association of Criminal Defense Lawyers in Washington, D.C. She manages the day-to-day advocacy operations in support of progressive criminal justice reform policies. Timothy Martin is a Commonwealth attorney for Augusta County, Virginia. He is currently the chairman of the Blue Ridge Criminal Justice Board and will share his views as a prosecutor on the efforts made in the community regarding pretrial justice. And finally, Brian Kennedy is a senior assistant public defender in Fairfax County, Virginia. He is a policy director for Justice Forward Virginia and is active in state coalitions that advocate for legislative change in Virginia's pretrial system. And to start things off, Marc Levin will provide our session's keynote on the recent topics related to national criminal justice reform and its potential implications for Virginia. Marc, I turn it over to you.
Thanks so much for inviting me, and it's great to be with such a large group. And I wanted to start out by just going to my first slide, and in reference to that, today would have been actually last week would have been the 47th birthday for George Floyd. And of course, his killing sparked a national discussion, and I think really brought to the forefront the racial disparities both within the criminal justice system and our society as a whole. And I think it's interesting to think about, if he had not died in the process of being arrested, what he might have encountered in the justice system. He had lost his restaurant job amid a pandemic. Would he, of course, struggle to afford bail, to afford representation? He had medical issues that would have made him more vulnerable once he got to jail. And so what I really took home from this is we have to design the justice system around those with the fewest resources and the most vulnerabilities. And of course, actually 80% of people ultimately get appointed counsel. They can't afford a lawyer. So whether it's economic, health, or otherwise, we know that people coming to the justice system disproportionately have vulnerabilities and needs beyond those of the average person. Now, it also, I think, illustrates the difference between equity and having equal treatment of everyone may not be equitable. Just giving the same, if you said everyone's going to get a $5,000 money bond if they had a property offense, right? Well, some people can't afford to pay that. So that's equal on the surface, but it's not equitable. And in fact, cookie cutter justice is not justice at all. The other interesting kind of footnote to this is in the last, I guess it was, I'm not sure exactly when it was, but the officer who, of course, kneeled on George Floyd was released with a $1 million bail, and somewhat unusually, he can leave the county and even the state. You know, it reminds us that bail is not punishment, which is something that policymakers often need to be reminded. And of course, given how familiar how people would recognize him, Officer Chauvin is probably of little risk to flee. So it's not, but again, no, we don't know where the $1 million came from or the 10% of it, but the bottom line is it shows that a wealth-based system is arbitrary in many ways. So let's turn now to our next slide and start to look at the challenges Virginia's facing when it comes to bail and pretrial issues. So first of all, basically, there's when you compare Virginia to other states, there's a much wider ability for judges to either deny bail or to require a secure bond. So, for example, a defendant with a prior felony or who's out on bond for an unrelated arrest or on probation or parole, even for something relatively low level, they have to be given a secure bond. And those are mandates that you don't see in many other states. So that again locks in kind of an unfairness to people that cannot afford a secure bond. Also, there's dozens of localities in Virginia where there's not a pretrial services agency, and then also there's a lack of robust police diversion, which is an important way to keep people from getting to jail to begin with. Although we have seen some expansion of cite and summons in Virginia since the pandemic started. Another challenge is, and this began in 1996, a long list of offenses, now over 40, that trigger a rebuttable presumption of detention. This basically means that for certain offenses, including drug dealing, possession of a knife on school property, recruiting a gang member, there's a rebuttable presumption that the person should be denied bail. And that's not something that really, actually, if you compare it to the Salerno decision by Chief Justice Rehnquist, he said there's a presumption of release, and it's up to the state to prove otherwise. So it kind of turns that on its head. I think as we look at it, there's now about 24,000 people in jail in Virginia. It has declined slightly since the pandemic. Nearly half of them are pretrial detainees. And I think a particular issue is that you have a lot of people with mental health challenges, people with drug overdoses, and there are not necessarily other places for example, a police officer to bring that individual other than jail. In San Antonio, Texas, for example, there's a 24-hour mental health crisis center that officers can use instead of the jail. So we need to create more off-ramps from the justice system. Let's look at our next slide. Since 1970, pretrial incarceration has gone up 800% in Virginia, and that's actually only to 2015, which frankly illustrates another challenge, which is a lack of reliable or even available statewide data on jails. That's obviously an enormous increase over the decades. And some of the factors for that are our reliance on commercial bail and unaffordable high bail amounts. More than a third of cases, including many misdemeanor cases, bail is actually denied to the defendant. Again, the prevalence of mental health and substance abuse disorders and the lack of treatment options. And this is particularly a problem in rural areas where even if there was a treatment option, it would be a very long drive to get that individual into treatment. And then delays in providing counsel and resolving cases, which can stem from a lack of availability of defense attorneys to appear at arraignments and other pretrial hearings. So just to give you an idea, the rural incarceration and in small and mid-sized counties has continued to increase, but actually starting in about 2010, suburban county pretrial incarceration jail growth in Virginia actually turned downward, and urban areas are basically stable. So it is in the rural and small to mid-sized cities in Virginia that we're continuing to see jails grow. So as we move forward, I think one of the things that we need to do is really look at what's the effect of keeping somebody detained before trial. And first of all, it perverts the process, right? Because as I said at the outset, punishment is supposed to occur after the adjudication, right? And what we found in looking at the bail litigation, and this was referenced by Alec in his speech in the first part of this forum a couple weeks ago, but the routinely in Harris County, which was in Houston, Texas, misdemeanors, for example, the vast majority of those people were actually ultimately getting probation, but they couldn't afford bail. So the brunt of the punishment, which was the incarceration, didn't occur from a sentence, but rather by default because the person couldn't afford bail. And so that is a big problem. First of all, some people are innocent. And indeed, it was discovered some of the substances in drug testing weren't actually illegal drugs a year later in Houston. So some of the people are never convicted, but even those who are convicted of something that didn't turn out to be serious enough to give them a sentence to incarceration already may have lost their job, lost connections to family and housing. Obviously, the cost nationally, pretrial incarceration is about $13.6 billion a year. So, and I think the most important point is, what is the research? And in fact, the University of Cincinnati has looked at it and said, even after 24 hours, for all but the highest risk defendants, the increased chance of rearrest because of having connections to employment and family and housing, having those severed, there's actually on net an increased chance of being arrested for the same risk person, again, except for the very high end of the spectrum. And we do recognize there's a need to deny bail, in our view, regardless how much money someone has, for those who are extremely dangerous based on an assessment and an adversarial hearing. And I'll talk a little bit more about that. Let's go to our next slide here. So this illustrates some of the reasons we do need to pursue bail reform. And I think the Virginia actually is a national leader when it comes to risk assessment and has been for many years. And I think that's very positive. But what we do know is obviously the risk assessment should not dictate the judge's decision, but it certainly should inform it. And there are some challenges, obviously, with making sure we don't use proxies for race or socioeconomic status. So, for example, one can exclude from risk assessment prior drug possession convictions, knowing that that's going to cause a very disparate impact if you include that, even though it's not it doesn't create a danger to public safety. Basically, people of all races use drugs in the same amount, but the chance of having a drug possession conviction is much higher for African Americans, for example, because there are more police in the neighborhoods and they're less able to get their drugs surreptitiously, right, than somebody who's wealthy and in a neighborhood that's not heavily policed. And then the other interesting thing is a lot of risk assessments look at failures to appear. And when you actually delve into the research, you find that most people who fail to appear do then show up, whether it's a week or two later. So that's different from absconding. Somebody who absconds for a month, 2 months, 3 months, that really ought to be the focus as we assess someone's risk. And indeed, what we've found since many pretrial service and probation departments, since the start of the pandemic, they've moved to remote hearings and check-ins. And in New Jersey and Michigan, the failure to appear rate basically went from about 15% to 2%, which was an illustration that people were not coming, not intentionally, but before it was because they couldn't get off of work. They didn't have transportation. They didn't have childcare. They were sick. And of course, one of the really neat things is now the ability to use apps and other technology for someone to be able to let the court know in advance that that's why they're not going to be able to make it. So it doesn't even end up being a failure to appear. So one of the other things is, of course, that sometimes commercial bail gets viewed as a free market solution, but the consumer isn't really the defendant. It's the judge or the public. And so it's not like me walking in to get a haircut, right? So you don't have the normal feedback mechanisms. And a lot of times the forfeitures are never even collected. So those are some of the issues. And then of course in Virginia, we see not much use of unsecured bond where someone would just promise to pay a certain amount if they don't show up. We don't see cash deposit used really where someone would basically give some money to the county that they get back in the entirety if they show up. Or posting collateral. So there's other ways to do this. And I would say basically you can have a very good pretrial system, little or no use of money bail, although if you look at the federal system, for example, having white collar individuals turn over their passport, right? That makes a lot of sense. So there's lots of different types, and what we really need to do is look at it as a financial condition. First, we make the in and out decision. Is this person in the small category of individuals who's so dangerous they cannot be released under any conditions? And then you decide what the conditions will be if they're not in that category, financial or otherwise. So let's turn to our next one. So New Jersey is an illustration of this. In 2017, they enacted significant bail reform. Unlike Virginia, they had a constitution that severely limited the ability to deny bail, even in very serious and violent cases. So they corrected that, but they also created basic presumption against the use of money bail, and it's very rarely used now. And they invested $10 million in technology and training for judges. And what they found is they've had very good public safety outcomes, no increase in rearrest or reappearance rates. They've reduced jail populations by 20% even before the pandemic. Only 7% of people ultimately are getting detained prior to trial, which is different than the 37% in Virginia. So I don't believe New Jersey are better or worse than people in Virginia. Now, there may be some differences, certainly in violent crime rates. So I'm not saying every state should have the same level of pretrial incarceration, but that's a huge difference. Now, I will say a cautionary note is they don't elect judges and they don't even elect district attorneys in New Jersey. And they have the preventive detention net was very wide. Anybody can basically be, for virtually any offense, be denied bail. And it hasn't been overused in New Jersey, but I think that gets back in part to the training and the fact that the system is kind of out of politics since not elections. So I think as we look to the next slide, I talk about some of the protections that we would want in the preventive detention net, so that if as we move away from unaffordable bail, and I would argue we need to say that no one should be in jail simply because they can't afford a bail amount. So if we say bail has to be affordable, then that means we're going to be relying solely on preventive detention to keep that small group of individuals who are too dangerous to be released behind bars awaiting their trial. So that's why we need to ensure it's not overused. We need to make sure the burden of proof is on the state to prove there's no set of conditions under which the defendant can be safely supervised in the community. There was a bill last session in Virginia that would have required a written reason for denying bail, which seems the most basic thing to have and is common in other states. Then looking at designating many low-level offenses that should never trigger pretrial detention, absent of special circumstances, or a pending or recent highly serious violent or sex felony that defendant is that's on their record. And then very important, requiring clear and convincing evidence of guilt in the instant charge, not mere probable cause, because we don't want it to be just more than a coin flip. We want there to be a high degree of confidence, because we're about to, as I said earlier, possibly the punishment before the adjudication. And then this is so important, adversarial hearing that's prompt. And as we have in Texas, there's a fast track appeal, and it can go all the way up to the state's highest court, taking precedence over all other cases if in fact the local judge determines after an adversarial hearing with representation that the defendant should be denied bail. So there's a lot of solutions that Virginia can look to, and I'll go off the slide here without any slides for a minute, just to tell you some of the areas that I think y'all should look at are unpaid fines and fees. A lot of people have warrants issued because they didn't pay a fine or a fee, and in Virginia even there's a $10 fee to get on an installment plan, and there's also limits on a judge's authority to waive reduce fines and fees up front. We've corrected that in Texas through recent legislation, because you can tell at the outset in many instances there's no way that individual will be able to pay that. So it's better to go ahead and make it realistic. And you'll actually end up increasing collections that way. We have the data from San Antonio. And of course, then you've got all sorts of outstanding warrants. And a lot of jurisdictions have really tried to deal with this in the pandemic, even getting rid of some that are many years old for very minor offenses, sometimes things that aren't even crimes anymore. And then you can also have a warrant fest, like in Spokane, Washington, where people can voluntarily come forward to clear out their warrants. Now, I referenced police diversion earlier, and there's a great model out of Seattle called the Law Enforcement Assisted Diversion Program. It's reduced recidivism by 60%, saved millions on emergency room and jail costs. And basically, this is in cases involving drugs and prostitution in certain parts of downtown Seattle. And it's now been expanded in Colorado and other jurisdictions. But basically, the officer hands off the individual to a case manager. They have emergency housing treatment available, and it keeps the whole thing from actually, there's no chance the individual will go to jail to begin with. Also, a number of other models, including civil citation in Florida. We have a criminal mediation program in Lubbock, Texas, that resolves disputes that in some cases would otherwise lead someone to go to jail. Both people obviously have to agree to participate. They've had tremendous success with that. Then obviously mental health, that's an enormous issue. And a few years ago, Pima County, Arizona, which is Tucson, they started doing thorough mental health screenings, and they've identified a number of individuals that they could get out of their jail and into mental health treatment. And of course, there's co-responder programs that are even being able to do that before someone is arrested with a great deal of success. And one thing they've done in Houston is identify frequent flyers, certain individuals with serious mental illness that for trespass and things like that were coming into the jail dozens of times a year. And now they've got a caseworker, sometimes with a law enforcement officer or probation officer, go into their home, at least once every week, make sure they're taking their medication. And it's really reduced those frequent flyers coming into the jail. So let me move on to my next slide here as we move towards concluding. I mentioned earlier indigent defense, and I just think it's so important. Basically, it evens the playing field. In Virginia, unfortunately, at the first appearance, often it's not meaningful. There's no discussion of bail sometimes. And so there was a bill from last session, House Bill 820, that would have required a person to be given a lawyer who's in custody for their first appearance, and that the judge would have also required the judge to consider arguments regarding bail at that first appearance. And so that's something that hopefully will be taken up again. I think one of the things is, as you do invest in indigent defense, even in a tough budgetary time, you will actually save money on the jail. We have some great data from Bronx Defenders, which is a holistic defense model that I highly recommend. Is basically the defense attorneys work with case managers, treatment providers. They actually solve the person's problem in the many months that often go by between the time somebody's arrested and when their case is resolved. It can be sometimes even more than a year. And I've talked to attorneys who've been able to get that person into drug treatment. And by the time the plea deal discussion happens with the prosecutor, they're like, I've solved the person's problem. They're back at work. They're not addicted anymore. And so now we don't need to give them a conviction. Let's just call it a day. So the data has shown that that type of representation actually produces much better results and saves incarceration costs. So ultimately, we're able to save more than we put in terms of strengthening indigent defense. Let me just go to our next slide now, where I'm going to talk about the need for collaboration. And I noted earlier that there's a dearth of data on jails in Virginia. In Texas, we have a jail standards commission. Now, it was set up largely to protect jails to some degree from lawsuits. So they would have to comply with certain standards, and they have to apply for exemptions if they're, for example, going to have people sleeping in the day room for an extended period of time. And the other thing the Jail Standards Commission does in Texas is publish data on every month about jail populations, how many are pretrial, how many are in each different category. And I think the other thing you can see is if you can establish a local coordinating council, bring together the judge, the DA, the sheriff, lots of different stakeholders, and identify those people who are languishing in jail for small bail amounts and work out solutions jointly that are viable in that community. And in Palm Beach County, for example, they've created court navigator positions where in the prosecutor's office, they go in and hone in on those individuals who have been in jail for low bonds, $500, $1,000 after 3 or 10 days, and they figure out what's going to be needed to safely get that person out of jail. So I will wrap up in saying that I think Virginia has a tremendous opportunity here to really both right-size its use of pretrial incarceration, ensure due process, and also at the same time protect public safety. So I look forward to answering your questions and hearing your comments. I wanted to mention we do have a couple of poll questions as well. Perhaps you might want to go to one of those now. That deal with kind of taking folks' temperature on what we should be doing in this when it comes to bail reform in particular. And while y'all are voting on that, let me also say we will be sharing with you a longer version of my presentation that's I think got about 24 slides or something. I didn't want to go into such detail so we could have time to have a exchange and also hear from the tremendous other speakers we have with us today. But the first question is, should cash bail be eliminated? I think y'all just took a look at that one. Looks like 81% voted yes. And then do you want to do the next two also?
Sure, let's do that.
Should pretrial assessments have a role in pretrial decision-making? Obviously, bearing in mind they need to be validated on the specific populations and make sure not to hopefully include factors that would be proxies for race, socioeconomic status, as I mentioned. But still, it's a controversial subject. So we'll see how people think. 93% in favor, which is my position too, as you probably know. And then I guess we'll do the third one, which was one I suggested. Should cash bail, if used, be set at an amount that is affordable, coupled with the ability for a court to preventively detain someone in certain cases, hopefully with certain limitations that I mentioned. And so we'll say, I have a feeling this one's going to score pretty high. 95%.
Excellent.
Well, thank you all very much. I'll turn it back to Nick.
Thank you very much, Mark. I appreciate it. Just to let everyone know, I am seeing the questions coming
Looks
in
like
the
he's on
Q&A
mute.
session.
Oh.
Can everyone hear me? We're back on? Excellent. So I am seeing, just to let everyone know, I am seeing the questions pop up in the questions and answer panel. I'm just going to save some of those questions for the end, just to make sure that we have enough time for all the panelists, but we do have time reserved at the end to answer all of your questions. So next up, I'm going to turn it over to Monica Reid, who will talk a little bit about her work with the Virginia Pretrial Justice Coalition, as well as, I'm hoping, a little bit of conversation about the Crime Commission study. Monica, the floor is yours.
Thank you so much, Nick, and definitely glad to be here, and definitely was taking notes during Mark's kind of presentation, because there are certain things like he kind of touched on, especially in terms of the legislation that was considered, that the coalition considered. So hopefully I'll be able to provide a little more information, and then obviously taking questions on that. But I do want to highlight, I will highlight one, our work within the Virginia Pretrial Reform Coalition. And I think it encompasses a lot of other groups, us being one of them, a lot of other state and local and court watches who are a part of that coalition. And we had formed, I want to say, around the end of 2018, knowing that there was a potential for criminal justice reform as it relates to pretrial reform. And so wanting to bring everyone who would have an interest in that to the table, and to see where we could have some synergy in terms of looking at reforms. But even before talking about that, I want to just backtrack to the Crime Commission, just because it kind of shaped a little bit. It'll make sense when I talk about the Crime Commission's work, when I talk about some of the pretrial reforms that the coalition has pursued and will be pursuing again in the upcoming session. So to backtrack, for those who may not be aware, in 2017, the Crime Commission was tasked with the efficiency of various pretrial release mechanisms at ensuring public safety and appearance at court. This is kind of under the banner of the Virginia Pretrial Data Project. So starting in 2017, they had worked with state agencies to capture a whole host of data on approximately 23,000 individuals who were arrested in October of 2017. And they followed their cases through its conclusion or December 31st of 2018. And this is kind of when the coalition kind of started to form at the end of 2018, just for a timeline's sake. And during the collection of the project and throughout the project that it's still ongoing, staff at the Crime Commission had expressed repeatedly the difficulty of gathering all of the data. It was very complex. Virginia, we currently lack a unified data collection system. And so in being able to pull this data that they even got together on the 23,000 individuals was juggling between about 9 agencies, I want to say 9 different state agencies, in order to even pull that data together for their project. And so that is something that kind of really informs the legislation that I will talk about later that the coalition had pursued in 2019 and 2020. But on the Crime Commission's data, so this process, even though, and one, I want to note that, so the data, I guess the raw data, so to speak, isn't guaranteed to be public. It could be public. It's a decision that has to be made by the members of the Crime Commission. So that's something. And when we were at the start of the Crime Commission's pretrial data project, I would say there was an election in between then in 2017 and now. And so the leadership has changed. When we were meeting with the leadership and meeting with staff, we expressed different views in terms of whether or not it was likely that the raw data would be released. And so that's something to note, that the leadership has changed. And it is something that the coalition is pursuing in terms of releasing that raw data that the Crime Commission was able to collect during their project. It resulted in an accumulation of hundreds of data points, literally hundreds of data points, from demographic information to pretrial detention periods, to bail setting practices, to sentencing outcomes. And it has the potential to be a rich source of information that can really allow for a broad, robust, and detailed snapshot of Virginia's criminal justice system and its pretrial system. And so that's why we are really encouraging the Crime Commission and continuing to encourage them to actually release that data, the data they collected during this project. The equity implications of the data are very clear. The study even confirmed that minorities are disproportionately represented in Virginia's criminal justice system, with 40% of the approximately 23,000 individuals that the project consisted of being Black, despite African Americans only making up under 20% of the Commonwealth's population. And so that's just kind of a snapshot of one of the kind of implications that we could really use the data to work on Virginia's pretrial and criminal justice system. So we're kind of continuing to do that, encouraging them to continue to publicly release that data. As it relates to how that influences some of the legislation that the coalition has pursued and will be pursuing, one of those bills was a pretrial data transparency bill. And this was introduced in both 2019 and in 2020. And it's something, so this would kind of expand upon what the Crime Commission started in terms of their pretrial data project. The difference is the legislation would create a continuous and sustained collection process. And that's the difference with the Crime Commission's project does not do, right? It's creating a snapshot of that time of those individuals who were arrested in October of 2017. What the bill would have done was create a continued and sustained collection process of that data. And so in 2019, there was a House and Senate bill, and also in 2020, House and Senate bill. Senator Jennifer McClellan on the Senate side for both years, and Senator Jennifer Carroll Foy in the House side for both years were the patrons on that legislation, and would have mandated the collection of this specific set of data on individuals who are held pretrial in Virginia. And it would have required that data to be made public available. Again, that's something that we are seeking for the Crime Commission to do on their pretrial data project. In terms of the other legislation that's been a priority for the coalition, and it's interesting because even Marc mentioned it in his presentation, and that was the Council at First Appearance, that HB 820 that was introduced this last year was one of the coalition's bills that we sought to be introduced. And so I'm glad that he was able to highlight the importance of that bill and having counsel at First Appearance. And so that is something that we will continue to pursue as a coalition. We hope, this special session is just wrapped up. And there was a lot of momentum around policing and criminal justice reform. But again, really wanting to make sure and emphasizing the importance of why having counsel at an early appearance is so important, and especially in reducing Virginia's pretrial detention rates. And again, there's a lot of kind of racial justice aspect into pursuing even counsel at first appearance legislation, because we know that people of color, African Americans, people of color are overrepresented in America's jail population. And so advocacy for counsel at first appearance can really be shown to reduce these jail admissions and length of stays and bail amounts as well. I want to highlight something that I just even, kind of looking over for today's session. NLADA recently released a policy brief on access to counsel at first appearance. And I saw something that was really two kind of field studies that they had in their report that really kind of show the impact of providing counsel at first appearance. I just want to highlight about one or two of them that they highlighted in the report. And one was from Baltimore, Maryland. And they had an experiment where half of a sample group of persons accused of crimes were provided counsel at bail hearings. And they found in their study and experiment that those who were represented were 2.5 times more likely to be released on their own recognizance without paying bail, 4 times more likely to have their bail amount reduced, and 2 times more likely to be released on the day of arrest. Another locality that they highlighted in the report was from upstate New York. They had some new programs related to counsel at first appearance, and they saw an increase the percentage of people who were released after their initial appearance by almost 21% in one county and by over 15% in another county. In Michigan, they highlighted 3 counties that had pilot programs around counsel at first appearance, one being Kent County, that had 11% reduction in the number of hearings due to increased pre-hearing dispositions. I want to say it's Ingram County, but I could be mispronouncing that, saw a 28% reduction in the amount of time that the accused spent in jail between arraignment and release. Huron County, I'm pretty sure I'm mispronouncing that, but they saw 18% of the accused in that particular county had their cases resolved at first appearance proceedings, representing an 8% increase from the previous year. And so just really highlighting, I would definitely encourage you to take a look at that report as well from NLADA. In terms of the counsel at first appearance, but those 3 kind of really highlighting the impact of why having counsel as early as possible is very important. And I think in terms of reducing pretrial detention, and so that's why it's a priority for our coalition. Again, Virginia, I think, there's looking at even the cost of reducing our pretrial detention rates. That's something to consider, because even though both programs may have a smaller, somewhat fiscal impact in terms of setting up a process for collecting the data, right? If we start collecting this data statewide and sustained, there may be a kind of initial cost related to that. You could talk about if there be any costs related to providing the counsel at first appearance, but really looking at what Virginia could be saving if it reduces its pretrial detention population. And again, we're talking about people who are presumed innocent. So, right, people who have not been convicted, people who have been arrested, and who are being detained pretrial because they can't afford to post bail. And so really looking at that is something that we hope that officials will consider. These 2 proposals are something that have been endorsed by the Virginia's African American Advisory Board in terms of the pretrial data transparency legislation and the counsel at first appearance legislation. I will stop there. I will welcome any questions either now, Nick, or at the end of the presentations.
Thank you, Monica. I really appreciate it. One question that did come up, and actually something that I thought of, you mentioned the difference between, and I'm going to mess up the legislative language, but the pretrial data transparency legislation that you're working on, the difference between continuous versus snapshot data. What was your coalition hoping to gather from the gathering continuous data versus what were your concerns about the snapshot data? If that makes sense.
Yeah, it does make sense. And I think if I understand, so again, the snapshot, it's good as a way to gather information and kind of make decisions from that particular moment in time. There's things that you can gather from it. I'm sure one being, like we said, the racial disparities, information data point that we can gather that 40% of that snapshot was African Americans, even though we make up only less than 20% of the general population. So there's something to be said of the snapshot, and I don't want to, minimize the importance of that. That's why we are calling for them to even release the raw data related to that project until we can get more sustained. But I think in terms of we're looking at reforming Virginia's pretrial system, if we're looking at examining the use of bail, its impacts on, failure to appear and whether or not someone will, likelihood of being arrested, being released pretrial, we need to have continual data, right? We need to be able to see the progression, right? Even once we have, reforms in place, how was our system prior to that data, right? And how being able to see it progress, are we improving? If we made a reform at the beginning, how is that reform actually improving the system? And that's something that we can't evaluate right now, and we won't be able to evaluate if we don't have a sustained data collection system versus the snapshot that the Crime Commission's project is doing right now.
Thank you so much. That added perfect clarification for me. Thank you. So next we will pass on to Timothy Martin, who will be focusing on efforts in his local community to reform local practices and policies, and how they've achieved those reform efforts within the existing laws in Virginia. Timothy?
Thanks. So what we've done here in Augusta County, which is a jurisdiction of about 75,000 people, some of which is suburban and some of which is rural, is we've partnered with the local law enforcement, our largest local law enforcement partner, which is the Augusta County Sheriff's Office. They're also not just jailers here, but also responsible for daily law enforcement duties. We got together with them and have instituted a pre-charge diversion program, which is unique in Virginia as far as I know, because we have a magistrate system and it's a bit cumbersome to do it here. We don't have one of these situations like you do up in Wisconsin, where the person gets arrested and then every charge is reviewed by a district attorney. It just doesn't work that way here. So what we ultimately did was steal from Eau Claire, Wisconsin, their pretrial pre-charge tool. It's a proxy tool. It's 3 questions long, and give that to the men and women who are on the street here. And then we chose certain crimes that were going to be eligible for this program. They're low-level offenses such as driving on a suspended license, trespassing, underage possession of alcohol, marijuana possession, and I could go on a little bit. But the bottom line is the man on the street, so to speak, the local law enforcement official, checks off this proxy tool and then refers folks, they don't summons them, they don't arrest them, they refer these folks to somebody in my office. They come and meet with them the following Wednesday, and if they're deemed appropriate by both the deputy sheriff and the assistant Commonwealth's attorney who works for me, instead of ever being charged, they get out on a litter remediation crew. We have a van. They meet at a parking lot, usually the Walmart parking lot, and go to some area of the county that has litter on the roadside. And the folks participate in a litter pickup program. They put the litter into orange bags, which the Virginia Department of Transportation is happy to come by and get, because actually it's their responsibility to pick up the litter in the first place. So they're happy for us to do that and then come get the bags and take it away. And if the person stays arrest-free for the following 6 months, then they never are charged. If they fail in any aspect of the program, then we just go through the normal channel. They'll be arrested, and then they'll go to court just as if they weren't given the opportunity. What we have found in this program is much greater success on the criminal justice side than I expected. And I say criminal justice side because for me, there were 2 benefits to this. One is environmental. Having garbage everywhere is disgusting. I ride my bike around this county, which is quite picturesque, and seeing the McDonald's garbage just makes me crazy. So having that, I knew that that would be successful, because if you get 10 people out on the road picking it up, it's not long before you see a pretty big impact. But what we've seen on the participant side is on the law enforcement side, the justice side, has been very heartening in the sense that we haven't had anybody come back yet. We haven't had anybody be rearrested yet over now years of the program. We haven't had very many failures. We've had a couple. We work with people early on in the program, but eventually if they don't show up on time, ready to work, then they're just not suitable. And so then they go through the system as it was. Many of the reforms that you mentioned are already in place here in Augusta. Here in this area, we have lawyers at first appearance for folks. And so a lot of the things that you all are talking about, we already have. Now, some of Marc's positions sound a bit harder and faster than maybe mine would be. We've got a bit of nuance to it in the sense that the total elimination of cash bail hasn't been something we've done, though it is in quite limited use, and measures are taken to see to it that nobody is held pending trial just by virtue of the fact that they can't afford to post. So anyway, but in terms of our local, the thing that's unique here is this diversionary program. The greatest benefit that I've seen to it so far is that a lot of the folks who come through the program have had no work experience at all. And in fact, in their lives have not had work modeled for them. Their parents didn't necessarily work. They didn't previously have that as a value. And a lot of the people that are on the litter remediation crews are, to put it kindly, were litter bugs themselves. So once they get out, however, with those gloves and pick up on the roadside, it's been really encouraging to see the change in those folks and in terms of their attitude toward society. And the only way I know how to put it is that many of them have transitioned from the margins into society. So instead of being out there as someone who's not known what it feels like to contribute, now they are contributors. And we get emails from these former participants all the time saying, hey, I just drove by that stretch of road and it is littered up again, and I'm really incensed about this. But just the fact that they've gotten up in the morning, gotten out there and done this thing has increased their self-esteem and their sense of self-worth. And I think one thing that any practitioner who's been doing this for any length of time knows is that we want to bring up that already damaged sense of self-worth. That's going to help us reduce recidivism. So the way we do it now, wherein we bring someone in for their first minor offense, they sit in the courtroom with a bunch of other people who have been committing crimes for a long time, and then we beat down a psyche that is already somewhat fragile. That isn't the recipe for success going forward for those folks. I mean, it's going to hurt their self-worth. And when their self-worth is damaged, they are much more likely to return. I tell a story to folks when they ask about the program and what I see as its greatest benefit. My grandmother struggled with her weight. In fact, she was obese, and at some point in the 1970s or so, joined, I don't know if it was Weight Watchers itself or some other weight-reducing group of people, and I could even have the decade wrong, but essentially it was in the early stages of anything like this. What they did, if the person weighed in, which they did in full view of everybody else, if they weighed in heavier than the week before, the other participants would join hands in a circle around the person and snort like pigs in order to sort of change the behavior of the person who weighed in heavier. Well, I think everybody who's listening to this would understand that that would not work. That would hurt the people's feelings, and then they would go home and not treat themselves better, and in fact, eat more, right? Well, that's essentially, from my perspective, what we're doing in the justice system now, where we're taking people who are already fairly fragile and beating them down. Now, what I'm speaking of are low-level offenders for the most part, whether you're talking about people who struggle with addiction or other relatively minor crimes, driving on suspended operators licenses, things like this, crimes that don't have victims. I don't know that we would find a lot of points of agreement between me and some of the more reform-minded people as to serious violent offenses. I have a different mentality for that. For me, that's a public safety issue and is somewhat non-negotiable. But when it comes to the run-of-the-mill, the guy who's breaking into the shed in order to sell a weed whacker for one hit of methamphetamine, or in my former life, enrichment heroin or crack cocaine, making that guy feel worse about himself is not going to work. That is going to perpetuate this problem. So from our perspective, one unintended benefit has been this shift. And the shift has been palpable and tangible, and we have seen the folks feel better about themselves once the program has ended. Plus, they have been held accountable. So another positive here has been that across the political spectrum, it has, in a sort of divided and binary world these days, it has received broad support. So folks across the political spectrum have voiced support for it, which I think anything we do, we should try very hard to get support across the aisle, so to speak, because even citizens today seem to identify themselves as one thing or the other. Terribly harmful, of course, but that's what we're dealing with. So that's our program, and that's what's unique about what we do. I could speak for a long time about justice issues in general and my own uninformed and probably halfway wrong opinion about some of the other issues, but that's what's unique about Augusta, and I suspect that's why I'm here. And any questions that anybody has, I would be happy to answer. I would be very bad at running the day-to-day of this program, but we do have someone who does that. And one final thing that I'll say about it, who's excellent, it wouldn't be me. The last thing that I'll mention about it is that over the years that we've been doing it, we've struggled for funding, as I think everybody can relate to that. So early on, I and my assistant bought pickers for the people, so they don't have to bend down. It's a little picker, kind of like a hook on the end. And they weren't very nice. They fell apart pretty quickly. So then we bought nicer pickers. But after some time, the county has bought in a little bit, which has been nice. And of course, this is not Fairfax, Brian, so our numbers are much smaller. But, having some buy-in from the county has been great. And then we started getting grants, $6,000 from a local community foundation and $2,500 from Keep Virginia something or other, I presume Clean or Green or something like that. And that's been great. It's helped sustain the program. But on Friday, we received a grant for $600,000. It's not that it came out of the blue. My guy worked on the proposal for a long time. And so that is going to be something of a game changer. And our goal, we have an advisory board that's informal, but I will present to the advisory board something that has to do with almost immediate drug treatment. So these folks can maybe get on our litter crew and get into treatment immediately instead of 6 months later after they've been caught and released, and then caught and held because they didn't show up, and we get into that big mess. So anyway, that's all I have to say at this point. I'd be happy to answer anybody's questions whenever Nick thinks it's appropriate.
Thanks, Tim. I appreciate it. I actually have a couple questions that are really specific, so I figured let's knock those out right away. So the first one is from Sandy Jones. Is the trash up pickup diversion program optional? And can someone opt out if they feel they're not guilty?
Yes, that'd be a real shame, wouldn't it?
Yeah.
So yeah, this is something that they have to agree to up front, and the officer says, hey, would you like to hear about this? And then at any stage they can opt out. And these are charges that qualify for court-appointed counsel. So at any point they can say no, and there's no pressure to join, but there is a great incentive to do it. So the incentive being you will never be charged at all. But no, there's no pressure or force exerted.
Excellent. And then I have two other ones. Shelby Johnson asks, who oversees the litter remediation crew in Augusta County? Is it the sheriff's office or someone from the Commonwealth Attorney's Office?
So that's a good question. For a while there, it was an assistant prosecutor. I'm sure he was thrilled with that assignment, but on Fridays and Saturdays, he would get out of his jacket and tie and put on some Carhartts, and he would go out there and participate with the folks, with strict instruction to make sure that it's something that builds them up rather than breaks them down. And he did fine with that, enjoyed it, but eventually the county relented and sent us an investigator, and that investigator is the one who generally drives the van, meets the folks, and gets out there and picks up. And on a couple of occasions, I spied on them, and I'm always impressed to see the employee out there bending down, picking up the stuff. He didn't drink any alcohol underage that we caught anyway, and yet he's out there working right with them.
And then one last question from Eric Schmidt. What if the defendant is physically incapable of participation? Is there an alternative for those individuals?
That's a great question, and one that I just hadn't even contemplated yet. I've put the first decision in the hands of the law enforcement officers so that they didn't feel like we were going behind their backs or putting someone in who, because they've interacted with them, they have found inappropriate for the program for one reason or another. We wouldn't want someone who was terribly belligerent. We do have, I should say, a therapeutic docket for folks who are struggling with mental illness to sort of capture that crew of people who may not react politely to law enforcement. But I have not yet had someone that the sheriff's department said, hey, this person is physically incapable. Could we come up with something else? I'd certainly be open to that. And it's probably just a shortcoming in my own head in terms of not having thought of that yet. But we would be happy to have someone in that program. And I wonder if really I prospectively cut that out by telling the officers what's involved in it, and maybe if they come into contact with someone who they can immediately tell wouldn't be up to the task physically, maybe they wouldn't even offer it to them. So that could be a shortcoming of the program. And believe me, I'm sure there are many, many shortcomings because we've been learning as we've gone, and it's been good. But of course, just like with any new thing, any risky thing, it's been bumpy as well.
Thank you very much, Tim. I appreciate it. And next, we will move on to Brian. Brian Kennedy will discuss his work with Justice Forward Virginia and their legislative work in Virginia. And hopefully he may touch on some of the work that they're doing in Fairfax County as well. So the floor is yours, Brian. Thanks.
Great. Thanks, Nick. I'm actually going to start with the Fairfax side of it because that'll lead into the legislative side of it. So where we're in Fairfax 10 years ago when I started was we had people held on all sorts of stuff, driving on suspendeds, first time up DUIs, grand larcenies. We were doing bond motions, bail hearings for all of those people. And things got slowly better over the years, but about 4 or 5 years ago at this point, and then in earnest 3 years ago, we started relooking at our office's internal practices when it came to bail, the public defender's office. Because basically we're like, we can only control judges a little bit, we can control prosecutors, not at all. So let's see what we can do to make things better. And what we found out was we had people getting arrested, they'd be arraigned the next day the court was open, which here is usually the next day. We're lucky that our court meets 5 days a week. We wouldn't get the paperwork till that afternoon. I wouldn't meet the client till the next day. I couldn't get a bail hearing on till the next day. So almost in a best case scenario, I wasn't able to get a bail hearing on for my client for at least 72 hours after their arrest, and sometimes more. And that was us doing that was if everything went perfectly at every single stage. So Mark mentioned it a little bit, but there's a lot of research that shows how you can destroy a person's life if you keep them locked up for 24 hours, let alone 72 hours or 5 days after arrest. And the statistics are really amazing. For low risk people who are arrested, their increase in a new criminal arrest, if they're held for that time, even if they're acquitted, right, of the thing they're arrested for, goes up by 40%. Their 2-year recidivism rate goes up by almost 20%. And that data is a little old, but even if someone's not guilty of what they did, the mere fact that they were held, they lose their job, they lose their family, just the trauma of being incarcerated, everything leads to their life being worse and our criminal legal system capturing them and them cycling through more. So that's obviously not what we're really interested in, is not hurting our clients. So we took a hard look and said, how can we do this faster to get bail hearings on faster? So we were trying to get in at arraignment at that first appearance in Virginia. And the judges in our court were not super interested in that, mostly because of the logistical challenges. It would have taken the sheriff, the judges, the court services agency, everybody doing things a lot different than we do now to get that to happen. And obviously, some of the things were out of our control. So luckily for us, our pretrial services agency, or what we call court services here, they were willing to work with us in a way that we were able to, between our office and their office, facilitate us getting the paperwork, getting to meet with our clients, and getting a bail hearing on 24 hours after the first appearance for almost every single person, with a few exceptions. And at least it's possible for us to do that if it makes sense for that client. So that at least has cut down to under 72 hours for most people, unless you're arrested on a Friday, which is better. But that's all we can do between the pretrial office and the public defender's office to make that happen. The struggles to make it go farther at arraignment is basically a lot of culture and the issue of having a large suburban, urban type trial court where our general district court has one of the highest dockets, if not the highest docket in the state in terms of absolute numbers. So it's really difficult to move the culture when people are seeing, if we move this one thing in the formula, we're going to have to move when preliminary hearings are, when our traffic dockets are, when everything else is. So in terms of that, that's where my push is for the work in the coalition that Monica was talking about in the bill that Mark referenced, of it's going to take the state legislature stepping in and saying, you have to have counsel at first appearance to make that happen across the state. Some jurisdictions have actually started doing this. Prince William County started the pilot program that their general district court judges actually really started and encouraged the defense bar to do. Now that they're going to have a public defender's office, the public defender is going to take over doing bail hearings at arraignment for most people. The city of Richmond has this in most of the time this happens in most of their courts. Tim, I don't think you guys are doing that down in Augusta.
Well, there is somebody, unless I am off on the terminology, there is somebody from the public defender's office in there, and the pretrial folks are outstanding. I mean, they have something there every single time. So it may be less formal, but we do have the capacity to do it. And I'll just say that the bar here is fairly collegial. We do have a public defender's office as well, and they staff those hearings. And I've not seen it where they weren't there. And the only limitation sometimes is we don't necessarily know the facts of the case. And so, because it just happened, so we haven't yet gotten that information, and that can be dispositive sometimes. So, usually we'll just say, hey, we'll hear this another day. But for the run of the mill case, everybody's there.
Right. And what we found, and it's good to know it's happening in a more rural jurisdiction as well. So it's happening in urban, big suburban, and then rural jurisdictions already. So hopefully for the legislators who are on the call, that'll be less scary, because it can work everywhere in all types of jurisdictions if we're able to make it happen. But we found that the same people who are getting out at a bail hearing 48 hours after arraignment or 24 hours after arraignment, not a whole lot has changed other than maybe everyone's done the work they needed to do. So they're getting out anyway. So it turns out that we're probably saving the county, because most people we do bail hearings for end up getting out at the actual hearing. So we're saving the county $250 a day, which is what the cost for Fairfax to incarcerate someone. And conservatively, we were saving over the 2 years, it was at least $500,000 to the county. And that was the most conservative estimate we had. That's not going in the state budget. That's a local spending versus state spending issue. But again, it's real money being saved. And that's even before you talk about how much money are we saving the community when people keep their jobs, when people are able to take care of their kids. Those are things that don't show up on a ledger, but are really clear community benefits, really clear cost benefit things that we should be talking about, that I think both people on all sides of the spectrum, political spectrum, can get behind, either values-wise or fiscal analysis-wise or both. That'll make a lot of sense. So the other thing we did in Fairfax that kind of briefly that we took a hard look at is the defense bar, or at least public defender's office. We weren't doing as good a job litigating these issues as we should have been, because it was just years of practice where it was, hey, this person's getting a secured bond, this person's getting a secured bond. In our own language, we were saying, give the person a reasonable bond instead of saying admit them to bail. And those sound like small things, but when even the advocates for the accused are buying into a financial, wealth-based detention system, or even worse, the preventive detention system, that's going to be a problem because no one else is going to make that change. The judges aren't going to do it and the prosecutors aren't going to do it. So through us advocating, that led to the judges thinking about stuff, putting in the data that Marc was talking about. The judges read our briefs, they were long, but they thought about it. We had a lot of new judges who were trained at their judicial conferences by people from our Department of Criminal Justice Services on bail. And they would reference that, oh, actually, I remember hearing about, this wealth-based detention doesn't make sense. Even the statute that Marc was talking about that requires secured bond in some cases, we were getting $1 nominal bonds under those circumstances. So everyone was getting out. But that took us doing a lot of, hey, we have to retrain our people. We have to fight the system from the inside. And I think it's, for the defenders out there, there's a cultural issue. Pretrial services directors, I think it's the same thing. Your staff needs to rethink about how they do things and not just buy into, this is how we always do it. And then you need prosecutors like Tim, regardless of what party you are, who've been thinking about these issues for a long time, starting to think about, can we do things differently? Can we ask things differently? And that's how we'll get change. Except that we're still going to boil up to things like the presumptions against bail in the statute that our state Supreme Court has basically said in some appellate decisions that aren't published, but bail decisions that they've heard, that's almost dispositive as some judges read those. They say, hey, presumption of innocence doesn't apply. You didn't say why the presumption's overcome. That's error. We're going to revoke the guy's bail. That it's really, really difficult. And our Supreme Court has made it really difficult for circuit judges and then district court judges to rebut those presumptions. And if we're going to talk about, we're not even talking about Marc saying clear and convincing evidence that it happened. We're not talking about, we don't even have something technically in our code saying least restrictive alternative like the federal system does. All of those would be great changes. All we need to do with that bill that was put in last year to get rid of the presumptions, which we did have, all that is the government, the Commonwealth, has to show the person's a danger, has to show the person is a risk of flight. And we don't even talk about that we should change what those mean in our minds. But the Commonwealth should have to prove that, not the defense prove the other way, that they are not that way. And if we're going to be real about due process, we're going to be real about the Constitution. At the very least, the government should have the burden to show the person is a danger, which means actual danger of peril, not you're going to trespass again in my position, or failure to appear, which is really absconding, not my kids were sick so I couldn't come to court. So I'll leave it at that, but say that even in places like Augusta, like Fairfax, where we're trying under the framework we have and you have partners who want to work together, it can't go that far unless we have statewide legislative change, which we tried, and it's always a multi-year process. But like Monica was saying, it's the beginning of criminal legal system reform in Virginia that has the support of liberal groups, left-leaning groups, but Americans for Prosperity in Virginia, very active with what we're doing. It's a bipartisan issue, even if it doesn't look like that when people vote in the General Assembly, and we really should be able to talk about it in a common sense way and not a political way. Thanks.
Thanks, Brian. Appreciate it. I just have one follow-up question that seems to highlight specifically, Brian, what you were talking about, and it's by Wesley Smallwood. It says, you raised an excellent point, Brian, regarding correct use of terminology related to bail and bond. How can we improve this area, as there are important implications when using incorrect language or terminology when making these release and detention decisions? How did you tackle that?
So I think for the lawyers in the group, that's what we're supposed to do. We're supposed to be intentional about our language, but I think courthouse law gets in the way, and shorthand gets in the way. So we need to be thinking about that. Virginia Code 19.2, 119 lays out the definition of bond and bail and secured bond. I also highly recommend the magistrate's manual, which you can find online, at least old versions of it, which does a really good job breaking down the terminology very intentionally. So I think it's educating ourselves about it and not falling into the trap. It's complicated. People don't understand it. Different states call it different things. But Virginia actually, for once, is following what the words actually mean in this area. We're good at that. So we should try to use those when possible.
Thanks, Brian. Appreciate it. So we're now going to start our sort of discussion session. So again, I would remind audience participants to use the question and answer section if you have any specific questions for the entire panelists. I'm going to sort of raise the first question, and I guess I would open this up to all of the panelists for their thoughts and feedback. We've talked a lot about where Virginia needs to go. We've talked a little bit about specific programs or initiatives or legislation that we can pass in order to move Virginia forward on the reform trajectory. I guess one of my first questions is, what do the panelists see as sort of the biggest or a couple of the largest barriers to Virginia continuing to move forward with reform? And I don't know if anyone wants to start first. Monica, I saw you unmute yourself probably first, so I'll let you take first stab at it.
Sure, I don't mind. That's a good question. And I'm kind of going to amend, because I've been reading ahead in the Q&A, sorry, Nick. And I saw someone said, you know, what was the pushback in 2019 and 2020? It's kind of trying to like merge I'm assuming that was related to legislation I mentioned, but if the person who wrote it is not, please let me know. I think the pushback on the pretrial data transparency, one has been costs, has been the fiscal impact, and what VCCJA, believes it will be costs in order to kind of implement that statewide uniform data collection system. Because we're talking about, I think I mentioned when discussing the Crime Commission, how they had reached out to 9 different state agencies that house the information, the data that they have pulled. So we're talking about systems that can kind of speak to one another, right? Making it easier for that information to live cross agency. And so that's something that would need to be done to have that sustained data collection for that legislation in particular. I think in terms of what may be hindering moving forward, one, I don't want to minimize costs. If you don't have to create a new system or you have to hire people to manage the system, those are real costs. So I don't want to minimize that. I think what I would like to do, and I think a coalition is trying to do, is really make the kind of put all the pieces together, so to speak. And so I think Brian kind of highlighted in terms of, we're not just talking, there's the tangible cost of, like, if we are actually able to successfully reduce Virginia's pretrial, detention rates, we're talking about tangible costs to the Commonwealth, right? If you have less people in jail who don't need to be there, there's a cost savings from not having to incarcerate them pretrial. We're talking about people who are not yet found guilty and just are being detained for whatever the reasons are. So there's that tangible cost. And then there are also those social costs related to having someone even detained for a few days, and I think Brian started to touch on that, but we're talking about if you're detained and you potentially lose your employment or your housing, or you have that disruption of the family structure that comes along with being detained even for a few days. And I think those are the social costs that we may be harder to quantify, but they do exist. And I think wanting to, make sure that we are putting all the pieces together in terms of our decision makers, making sure that, all of that's related when we're talking about reforming our system. And so there's the tangible costs, and there'll be the tangible savings, but also the social costs that are harder to kind of maybe figure out, but are tangibly related to the reforms that we're trying to do. And so I think, in in terms of looking at the last 2 sessions and where we've kind of come against roadblocks, so to speak, that's kind of been the cost. Yeah, I mean, I don't know if Brian has any other thoughts, but I think that's kind of been sort of related to some of the pushback, at least, that we've gotten in terms of those 2 particular measures. And I think, and I would mention, I think, and Brian, correct me if I'm wrong, I think in the last year, we were able to get, DCJS has to do a fiscal estimate on what it would cost to do a pilot program of the data transparency project. Okay, Brian's shaking his head, so I know I got it right. So that's something that should be forthcoming. So hopefully that will move the ball forward. And I think, in terms of the pushback for the author's question, I think in the early, especially in 2019, again, I think there was a lot of confusion around the Virginia State Crime Commission's project and what the bill would have done. And so I think the thought was like, oh, we already collect this data, or the Crime Commission's project's going to solve this, and that's just not the case. The data points that are outlined in the legislation aren't currently being collected, and we have confirmed that with meetings that we've had with staff at the Crime Commission. Agencies aren't collecting the specific data points that the legislation would have mandated, and so that's one thing. And I think, again, I think it was the beginning year, there was a lot of confusion around like, we're already doing this with the Crime Commission's project, so we don't need legislation, but really what we're finding out, we still need it. One, because again, the legislation is asking for points that aren't being collected by any state agency. And 2, because we need that sustained data collection and not just a snapshot of data that the Crime Commission's project is doing.
Thank you, Monica, I appreciate it. Tim, Mark, Brian, barriers for Virginia moving forward? Mark?
Well, yeah, I would say we kind of sometimes describe it as the wrong pocket problem, because of course, if you reduce pretrial detention, the sheriff will save a lot of money, but that doesn't necessarily make its way to pretrial services, to indigent defense. And, one of the things New Jersey did that was really important was investing in indigent defense and pretrial services. I think, and I said earlier, I don't think preventive detention should be on the table, right, for someone who's arrested for stealing a candy bar, even if they score high risk, right? But I do think pretrial services should be. And of course, pretrial supervision is part of that. And if somebody fails to comply because they're rearrested or absconds, then yes, they can be revoked to jail. I think that, and it probably is a bit of a difference of opinion. Obviously, I agree with Alec, who spoke last time on a number of things, including the harmful effects of pretrial detention for all but the most high-risk individuals. But I do see a much greater role for, I don't think it's the case that almost everyone can just be left completely to their own devices. I do, in terms of both services and supervision, that, and obviously we don't want to over supervise people. We don't want to take someone who has a first time DWI, who's got a stable job, no criminal record, low risk. We don't want to say they've got to come to the pretrial services office every week, right? But there is a happy medium, and certainly there ought to be a level of accountability, even while we recognize people. For example, in pretrial supervision, you need a warrant to search somebody's house, whereas if they've been adjudicated and they're on probation, you don't. So there is a legal distinction, but there still needs to be some level of accountability and services connecting people with mental health treatment, substance abuse treatment, management. So I really think if we invest the resources in those areas, we will in fact more than save that amount on the jail. And that's been the experience. If you look at places like Yakima County, they did Washington, St. Mary's County, rural, smaller counties. And in my longer slides, you can see the results there. They had net savings. They had no increase in people that were rearrested when they implemented pretrial services, counsel at first appearance, and similar changes.
Thanks, Mark. Tim, Brian, Tim?
The biggest impediment to any change is that we've been doing it this way for a very long time. And so whether it's the magistrate system that we have, and I'm not bad-mouthing that or any of the people involved in it, and you combine the fact that we've been doing it for a very long time and we have a relatively safe state. Those are 2 things that are tough to move. And of course, we don't want to move the safety side of it, except to the degree that it can be improved. But you take years, decades, even longer of doing things in government, and it is really hard to change it. And I'll tell you that, in our little corner of the state and our little program that we have out here, there was tremendous resistance from all corners at the beginning. And I found that sort of hard to wrap my mind around, because it's, you know, kind of a feel-good program. I didn't say, hey, you know, this guy, the mass murderer, we're just gonna send him out and have him pick up garbage. So the concept has wide buy-in, but pretrial services here was the catalyst for it. So I went there and told them, hey, I have this thing that I'd like to do. It seems like it should be very simple, you know, carbon form saying, go see this guy on this day and don't wind up getting charged. We are the charging authority here. And I'm not one of these people who subscribes to the theory that I get to pick and choose what I prosecute, in the sense that I think that's up to the legislature, and we are still prosecuting this. We're just doing it in a slightly different way. Well, we got way down the road. I mean, we were almost there, and then our hangup was insurance for this. We didn't have insurance, and so again, pretrial came to the rescue and found a way to get a rider on another locality's insurance plan. So, you know, there were just all of these impediments. And at a certain point, I think a lot of the time you push and push and push, and then you just throw up your hands and you're like, well, I guess I'll just work within what we have. Well, times change. And in that change, the system has to change with those times. And you won't find me advocating for I don't know how to put it other than to say a soft on victim crime approach. That isn't me, and it's not what I think. But change is difficult in a ship as large as the government and the Commonwealth of Virginia. And that's not a knock on any individual person. It's just the fact that that's a tough thing to get done.
Brian?
I think the one thing that no one's mentioned yet is it always comes up, and it comes up from members of both political parties whenever you try to make a change, even on bail, that what about the murderer? What about the rapist? What about this? And then people start going into anecdotes. And that is, both political parties have been for 50 years guilty of this and are currently both guilty of this in Virginia right now. And I think people need to remember, when we're talking about bail, we're talking about a very fundamental constitutional issue, which is that the government just can't be locking people up who have not been convicted of anything. That's what we're doing in Virginia. 37% hold rate, Mark, I think, said. That's insane. And if you think about the statute we have for bail, says failure to appear or an unreasonable risk of danger to themselves or the community. That's basically the same standard we have for a civil commitment proceeding. And that's not my idea. There's a great bail law review article came out this year on that basically says those two things are basically equivalent. If the government's going to take a regular person off the street and put them in a cage, it's going to be because they're a real risk of danger. And substantial risk in civil commitment, that's risk of physical harm to people. And that certainly, I think, covers really what Tim's talking about. He doesn't want people out there causing physical harm to other people. Colin McDonald, I'm going to give you a hard time for something you said in the question and answer. He's my pretrial director with Mark, where he says he doesn't want people on the street who have 30 petty larcenies open at a time. You know, I get why you don't want someone with 30 petty larcenies or 30 trespasses. I had a judge tell me last week, this guy keeps going back and walking on the same strip mall. If he doesn't stop doing that, I'm going to have to hold him till January when we're going to have a court date. I said, what does that have to do with community danger? That doesn't have anything to do with actual danger, let alone you can have a person charged with murder or manslaughter who's not a danger to other people based off the facts and circumstances of the case. It's obviously a harder sell, but it's possible. So I think we need to get away from what do we do with people who are convicted and talk about what do we do with people who are not? How does that fit into our constitutional structure? How does that fit into what we want to be? And then how can we do that safely? Which I do think there's room to do, even if there's some daylight between where Tim and I would make that decision.
This is fun. I just wanted to wanted to like jump in where Brian left off, because I think ultimately he makes such a good points. Ultimately, and I'm also answering a question that came in in the Q&A, so I keep reading ahead. I'm sorry, Nick. when someone asks about do the cost argument still exists and how do we kind of change that narrative and dialogue, and I think Brian, at least how I'm going to summarize it, kind of says that is I think it's Virginia needs to look at really just changing its value system, and that's essentially, I think, where are we putting our money in terms of the criminal justice system versus where we should be putting it. Obviously, I work for NACDI, I work National Association of Criminal Defense Lawyers. I'm always going to say that the investment in counsel, needs to happen. So investments in counsel and first appearance, investment in, in terms of training and making sure that we're adequately funding our public defender systems are necessary. So I think, and ultimately it's about changing our value system. Like Brian mentioned, like, why are we incarcerating people who are innocent? Why are we incarcerating so many people pre-trial? If we looked at our pretrial detention and we, seriously looked at whether or not people need to be there, we will have cost savings that can be diverted to other places. And I think so. Ultimately, we just need to change our value systems. Like he said, I mean, there's always going to be that a few anecdotes of something that happens, but ultimately looking at, do these individuals need to be incarcerated? Do we need to interrupt their family structure? Do we need to pull them away from their jobs? And potentially have them lose their jobs in order to, detain them pre-trial. And so I think if we are really looking at what are we putting our values on, I think this conversation, I won't rehash it here, it came up a lot during the special session and we were talking about some really tough issues. I'll just say that. But I think ultimately that's what we need to kind of examine.
Can I say something?
Go ahead.
So Brian talked about that daylight, in terms of where he as a public defender and then I as a prosecutor may different. Of course, a lot of that is just a distinction based on our positions. But one thing that I'll say, you mentioned that judge, and then you talked about your pretrial, the guy who runs pretrial where you are. There is something that hasn't been mentioned here, and it may be, distinctly unpopular among the other panelists and even the folks watching. But there is this difficulty in terms of what you do with someone who's charged with something relatively minor, but won't come to court over and over and over again. Eventually, the system is going to throw up its hands and say, well, we can't get you here. The police officers come 4 times, or the victim of this relatively minor thing, but still a victim, has come 6 times. They're missing their day at work. So eventually, mister, we're just going to have to hold you. And of course, the person who's failing to appear a whole bunch of times, I think we're all aware that that person is not necessarily, often there's a mental illness or drug addiction or something else going on, but eventually the system has to take a stand. Now, where in the process that point is, I don't know. Is it, hey, you didn't appear the first time, so you're not going to be able to fool me again? And I'm not going to try to say that thing. I've seen that work out poorly for another politician, the fool me once thing. But the bottom line is, at a certain point, there's a line that's drawn, and then you do have people who are nonviolent, who are held, even though they're not necessarily likely to hurt someone, and they're not absconders, but they are flight risks in the sense that we can't give them their day in court. And I don't necessarily know the answer to that, but a lot of those folks, we've just eventually said, hey, we're going to have to keep you because the victim has missed 3 days of work, and we're not doing that again.
Yeah, if I could mention,
Mark, just one note before you start. We've got just a couple minutes, so you're going to have the sort of last word. So go ahead.
Well, there are a lot of technologies now, other than kind of a clunky ankle monitor, that can help for one thing. And then, I would just mention the text messaging reminders with directions, 26% reduction in failure to appear. And then, as someone who's right of center, I'm rare to cite Washington, D.C., but if you look at their pretrial system for many years, they release 94%. 88% are successful, and only 5% or less have to post money or collateral with the pretrial services agency. And again, for a white collar defendant who could actually buy a ticket to go abroad, at least before COVID, there are people for whom that financial condition can make sense. But again, I think the idea is that nobody should stay in jail simply because they don't have a certain amount of money.
Thanks, Mark. Great points. And with that, I think we're going to wrap things up. That's going to conclude part 2 of Virginia Pretrial Justice System Fair and Equitable, or Time for a Change. On behalf of the Virginia Community Criminal Justice Association, I want to thank the panelists for taking part in this amazing discussion. I again want to thank the Miller Center of the University of Virginia for providing technical support for both part 1 and part 2 of the forum. Without their help, none of this would be able to happen. And finally, I want to thank the audience for joining today's conversation and the interest in pretrial reform and criminal justice reform as a whole. Those that are interested in helping, please reach out to Steve Austin or Pat Smith. I'm hoping Howard will be able to put up their contact information. There we go. And as a final reminder, both part 1 and part 2 will be available on the Virginia Community Criminal Justice Association YouTube channel and at their website at VCCJA.org. So thank you very much. I appreciate it.